This is Beyond Borders, the Immigration Evaluation Podcast, where you'll learn how to confidently conduct evaluations, connect with attorneys to gain referrals, and create a thriving practice. I'm Dr. Mariella Shibley, and I am here to help you turn your expertise into impact. Let's get started. Today, we're diving into a question that I get all the time from colleagues. And that is, when you're writing an immigration evaluation, what do you do with information that could hurt your client's case? And it's a tricky balance. On the one hand, we want to be thorough, we want to be objective, ethical. But on the other hand, we don't want to include unnecessary details that could derail a case. And there's a lot of confusion out there about whether there's some rule that says that evaluators should leave damaging information out or not. So let's clear something up right away. There is no ethical or legal standard that says a forensic evaluator, whether you're a psychologist, psychiatrist, or other mental health professional, should never include information that could harm a client. In fact, if a piece of information is relevant to the legal question you've been asked to address, then you're ethically obligated to report it, even if it's unfavorable. But the key word here is relevant. If something is irrelevant to the legal question, and especially if it's potentially harmful, that's when omission is not only permissible, but it may actually be ethically required. So let's ground this conversation in the ethical and professional rules that guide our work. These are not just abstract codes, they're practical guardrails that protect both our clients and our credibility as forensic evaluators. So, for example, the APA Ethics Code has Code 4.04a, which states, include only information germane to the purpose of the communication and avoid undue invasion of privacy. So what does that mean? It means that your report should contain only information that directly relates to the legal purpose of your evaluation. Irrelevant personal history or unnecessary details do not belong. So, for example, if your client casually mentions that she had an affair 15 years ago, that's not related to her current hardship or her asylum or her trauma case, putting it in your report would be an invasion of privacy and ethically inappropriate. Codes 9.01 and 9.06 state that we base our opinions on sufficient information and present them accurately. There is no cherry picking, but also no irrelevant tangents. So it means that you must gather enough data to support your conclusions and represent it fairly. But you don't leave out key information that affects your opinion, and you don't pad the report with unrelated material that dilutes your findings. So, for example, if you diagnose a disorder, you must clearly document the trauma exposure and the symptom pattern that support it. On the other hand, you don't need to include 3 pages of unrelated childhood anecdotes that have no bearing on the current legal questions. Also, Code 9.10, you explain results only to appropriate parties in ways that address the referral question. And what this means is that your report should be written for the legal audience, usually, in this case, is immigration attorney and the adjudicator or an immigration judge. And they have to be focused on the referral question. So avoid wandering into general therapy recommendations or advice. Now, we also have the specialty guidelines for forensic psychology to abide by. And many of these codes are consistent with the broader ethical code. So, for example, Guideline 9.02 says to limit discussion to issues relevant to the legal purpose. And that means that you want to stay laser focused on the legal reason that you were retained. This helps the court and the adjudicator, and it protects your neutrality. Guideline 10.04 says reports and testimony should be limited to data directly relevant to the legal purpose of the evaluation. So don't overload your report with every fact that you learned. Only include data that helps answer the legal question. For example, if a client discloses an old, uncharged shoplifting incident from when they were in their early 20s, if you're evaluating current psychological hardship, that detail has no probative value. So including it could invite damaging credibility attacks. Guideline 8.02 Avoid providing unnecessary information that could cause unwarranted harm. So if a piece of information could harm your client and does not serve the legal purpose, it should be documented in your private notes, not in the report. So suppose the client tells you that they decided to come live in the United States, so they got a tourist visa and entered the US as visitors and just stayed. Well, admitting to that would entail that they lied to the immigration officer, because if they told the immigration officer at the consular interview that they were moving to the US and that's why they wanted their tourist visa, they would have never been granted a tourist visa. And also, probably when they entered the country, they were asked what they were coming here to do, and they certainly didn't say, oh, we're moving here with a tourist visa, because they would not have been let in. So that would now meet grounds for fraud or misrepresentation. And it's a very unnecessary detail that you don't need to disclose. You can just say they came to the US without any mention of when they decided to come or how they entered or anything like that. Let the attorney work on their strategy, but that information is not relevant to the referral question that we have to address. So again, these are just the guidelines for psychologists, but every different profession in the mental health field has their own guidelines, and they are pretty similar. If you're looking to add a high-impact, high-income service to your practice, I've got something for you. Head to the link in the description box to check out my expert training in immigration evaluations, a comprehensive program designed to help you confidently conduct immigration evaluations, connect with attorneys, and build a sustainable practice. Now let's get back to the show. So bringing it back to immigration evaluations, the legal purpose is usually things like establishing psychological hardship or evaluating mental health or assessing credibility in asylum claims, or assessing trauma in survivors of violence or persecution. So anything outside of that, like unrelated, unlawful behavior from decades ago, or some juicy personal details or offhand remarks that don't affect their functioning or impact the trauma or hardship, it probably does not belong in the report. Every piece of information should pass sort of what I call the relevance and necessity test. So in short, does this help answer the referral question, or could it cause harm without adding legal value? Now, a quick but important legal note: even though opposing counsel could in some cases compel disclosure of your full file, even though that's never actually happened to me or anyone I know, but it could happen, your formal report should still be tailored to the scope of the retention and the adjudicator's needs. So including extraneous damaging information that has no probative value doesn't just hurt the client, it can actually expose you to cross-examination about bias or overreach or even breaching confidentiality boundaries. So that's why clarity about what belongs in a report and what doesn't is so critical. A recent podcast that we had with immigration attorney Jacob Sapochnik, he actually described a case where a client had no official record of entering the U.S. in 1999, and the attorney's legal argument was based on a lawful entry that occurred in 2005. So if the evaluator casually mentioned the undocumented 1999 crossing in the psychological report, even though the client disclosed it in the interview, that one sentence could completely undermine the attorney's strategy and jeopardize the entire case. So then the question becomes, is it relevant to the legal purpose of the evaluation? And in this case, the answer is no. The evaluation is about psychological hardship or trauma or functioning, not immigration crossings. So including that detail isn't required and, in fact, could cause serious unwarranted harm. And that's exactly the kind of information that you may want to document privately, but certainly leave out of the report. So if you want, you can always include a blurb on your reports that note its limitations. So for example, Here's a simple policy that you could adopt and even state explicitly in your reports. In accordance with whatever, if it's APA ethics and the specialty guidelines of forensic psychology, if you're a psychologist, or your professional board, my forensic reports include only information that is relevant and necessary to address the specific referral questions and legal issues at hand. Information not germane to the purpose of the evaluation and that may cause unwarranted harm is omitted from the formal report, but may be documented in private notes. So you could write something like that. It cites the exact ethical standards that are guiding your decisions. It shows that you still document what you learn, just not always in the report. So how do you make these calls in real time? So I use what I call the forensic report inclusion checklist, if you may. So ask yourself, is it relevant? Does it directly address the referral question or legal issue at hand? Would leaving it out mislead the reader? Number 2, is it necessary for legal purposes? Is it needed to support your opinion or required by law? Number 3, potential for undue harm. Could it cause unwarranted harm? If yes, is there still a clear legal or ethical reason to include it? Number 4, alternatives. Can you summarize or anonymize without distorting their meaning? Could it live in your private notes instead? And number 5, consultation. If you're unsure, talk with a retaining attorney before finalizing the report. So you can think of this checklist kind of like a flowchart, right? Is it relevant and necessary? Then include it. Is it irrelevant or unnecessarily harmful? Then leave it out of the report, keep it in your notes. Are you unsure? Consult with your counsel. So let's put it into context with a few examples. You're evaluating a client for a VAWA case. She mentions that decades ago in another country, she shoplifted an item but was never arrested or charged. Does this have anything to do with her current hardship claim? No. Does it shed light on her mental health functioning now? No. So if you include it in the report, what happens? Well, suddenly the attorney has to manage credibility concerns and explain away something totally unrelated. It just muddies the waters. And that detail belongs, if anything, in your private notes, but certainly not in the formal report. Another example. Suppose you're doing a VAWA evaluation and the client admits that during the abusive relationship, she sometimes lashed out physically toward her partner. Now, this behavior is part of the trauma narrative, and it might already appear in immigration records as well. So omission would actually be misleading. So this is one of those times that you have to include it. But how you include it matters. You don't just drop it in as a raw fact. You contextualize it. So something like, while the client acknowledges instances of aggressive behavior during the relationship, she described these episodes as reactive, occurring in the context of sustained abuse and symptoms consistent with complex PTSD or something like that. So that framing tells the truth. It keeps the report objective, but it doesn't sabotage the client by presenting the fact without context. Another example. Here's where it gets trickier. Imagine that you're conducting an asylum evaluation and the client discloses a history of substance use disorder. So let's say alcohol dependence that is now in remission. It has nothing to do with a persecution claim. So the question is, does it affect current functioning or credibility? If the answer is yes, so for example, if there are memory gaps or blackouts that play into the narrative, then it may need to be in the report. But if the answer is no, then omitting it from the report may be the safest and most ethical choice. But this is the classic gray zone, and when you're in a gray zone, you consult with the attorney. Let them weigh in on whether inclusion will help or hurt the legal strategy. That way, you're collaborating and protecting yourself. So here's the bottom line. We're not hired guns for attorneys, but we're also not there to sabotage clients with irrelevant disclosures. Our responsibility is to be objective, accurate, and laser-focused on the referral question. The best way to protect yourself and your client is to use a clear policy, a consistent checklist, and an open line of communication with the attorney. That's how you safeguard the client, yourself, and the integrity of the evaluation. And remember, relevance is your anchor. When you feel that pull to include everything that you've learned about a client, just pause and ask, does this serve the legal purpose? Or could it cause harm without adding value? That simple moment of reflection can protect your client's case, your ethical standing, and your credibility as a forensic evaluator. So as you move forward in this work, build your process around 3 pillars: a clear relevance-based policy, a consistent inclusion checklist, and open collaboration with the referring attorney. Those 3 things will help you navigate even the trickiest judgment calls with confidence. Thanks for joining me today. If this episode was helpful, share it with a colleague or supervisor who's navigating the same challenges, and I'll see you next time.